stay in prison for the rest of your life. You will never be eligible for parole. You were the only person with Preston that afternoon. It was you who did this. You murdered him. This forms the basis of your conviction on count 1. A whole life order is a sentence of last resort for cases of the most extreme gravity, which is reserved for the few exceptionally serious cases where the judge is satisfied that the element of just punishment requires the imposition of a whole life order. In a borderline case, if the judge is in any doubt as to whether this standard is reached, a minimum term order is likely to be the appropriate disposal. Each case will depend critically on its particular facts. The sentencing judge must undertake a careful analysis of all the relevant facts, as justice cannot be done by rote. In assessing whether the seriousness of the offence or offences warrants a whole life order, the court must have regard to the general principles set out in Schedule 21. In your case, Varley, not only the circumstances of Preston's murder on 27 July 2023 fall to be taken into account, but those of all the offences leading up to it over the course of 3 months, the details relating to which I have already recounted. The seriousness of your offending is exceptionally high, even in the general context of the offence of murder, and the appropriate starting point is a whole life order. Having determined the appropriate starting point, I must consider the aggravating and mitigating features. The aggravating features in this case are: 1. Preston was particularly vulnerable because of his age. He was not just a child, but a baby. 2. Both mental and physical suffering was undoubtedly repeatedly inflicted on him before his death. 3. The gross abuse of position of trust, namely that of prospective adopted parent. Your not guilty pleas are not an aggravating factor, but pleas of guilty would have been relevant when determining whether the seriousness of the case was exceptionally high. This is a factor which you're not therefore able to advance or rely upon in your favour. In mitigation, I accept that you did not intend actually to kill Preston, despite the fact it was almost inevitable that your assault on Preston would cause him really serious injury, and that was indeed your intent. As for premeditation, I cannot rule out the possibility that your attacks on Preston were not premeditated from the moment of his adoption. They did, however, fall into a pattern of repeated and persistent abuse, which very significantly dilutes the force of any argument relating to premeditation. You are also of good character, although I am bound to conclude that your character was one of the factors that led to earlier suspicions of your abuse being overlooked by professionals. As the Sentencing Council guideline on sexual offences states, the more serious the offence, the less the weight which should normally be attributed to this factor. Where previous good character or exemplary conduct has been used to facilitate the offence, the mitigation should not normally be allowed, and such conduct may constitute an aggravating feature. Balancing out these aggravating and mitigating features, I am satisfied that the starting point of a whole life order is also the finishing point. This is a case of the utmost extreme gravity. You will stay in prison for the rest of your life. You will never be eligible for parole.